from Wyoming, the senior member of the committee of the House from Wyoming, Ms. Hagemen.
The only. In March, the Miami Herald reported on a team of former U.S. officials and Venezuelans assisting the Trump administration with tracking Tendagua, or TDA. They have focused on ties between TDA and the Maduro regime, identifying 1,800 gang members sent to our country. Reportedly, 300 received paramilitary training in Venezuela, and the regime has operational control over them. Information obtained by the team from police agencies in South America has resulted in the arrest of at least 800 TDA members or smaller affiliated entities. According to the article, TDA has been setting up a drug distribution system in our country, and the individuals, quote, are not criminals sent to cause havoc. They are soldiers sent in an asymmetrical warfare operation against the United States, end quote. On March 15th, President Trump issued an EO invoking the Alien Enemies Act regarding the TDA invasion. The EO finds that TDA is perpetuating, attempting, and threatening an invasion or predatory incursion against the territory of the United States. TDA is undertaking hostile actions and conducting irregular warfare against the territory of the United States, both directly and at the direction, clandestine or otherwise, of the Maduro regime in Venezuela. Judge Boasberg of the D.C. District Court recently ordered the Trump administration to turn around removal flights bound for El Salvador carrying members of this Venezuelan terrorist group, TDA. Judge Boasberg's temporary restraining order at first was limited to the named plaintiffs, but he later provisionally certified a class for, quote, all non-citizens in U.S. custody who are subject to President Trump's order against TDA and its implementation. Mr. Larkin, what are the problems associated with the breadth of this order rather than it having being just applied solely to the parties in front of it?
There seem to be at least two issues. One is whether I'm told, I haven't seen the complaint, but I'm told that the complaint that was filed seeking relief was brought under the Administrative Procedure Act. That's not an appropriate vehicle for this. It should be the federal habeas corpus laws. But secondly, if you're going to grant class-wide relief, you have to first properly certify a class. The Supreme Court has so ruled and has told the district courts that they have to do first the job of certifying the class and only then awarding class relief. In footnote 1 in Baxter versus, I think it's pronounced Palmigiano, but don't hold me to that, the Supreme Court said the district court had gotten it wrong in that case for following the reverse order. So if that's what happens then is there are steps that you have to go through in order to certify a class. And to my knowledge, although like I said, I haven't followed that case, I don't know if those steps were followed here. My understanding is that this is the first I've heard of it from you, so.
Well, and there's another problem associated with that as well. In the case involving TDA, the judges and other injunctions that have been issued, nationwide injunctions issued by these courts, they have not been requiring the party seeking the injunction to put up a bond, even though Rule 65 of the Federal Rules of Civil Procedure mandates that a party seeking a preliminary injunction or TRO must provide security, a bond to cover potential costs and damages to the party who is wrongfully restrained or enjoined. In fact, such a bond is a condition precedent for an injunction to be valid. So in light of that, does this violation or failure to require the posting of a bond undermine, if not actually nullify, the legality of Judge Boasberg's order?
I have to say, and it's going to sound like begging off, but I'm not trying to, that I haven't researched that effect in this sort of context, in part because I'm not sure how you set a bond in a case like this, where what you're talking about is essentially relief that should be granted under the habeas corpus laws. And so to the extent there are separate procedures that you have to follow in a habeas corpus action, I don't know to what extent that part of Rule 65 would apply.
So what I'd like to do is I would encourage you to read the opinion article in the Wyoming Street, or the Washington, the Wall Street Journal from yesterday entitled "Why Judge Boasberg's Deportation Order is Legally Invalid." And this individual, Daniel Huff, goes through the analysis of what is required under Rule 65 for an injunction to be enforceable.
Yeah.
And one of the problems associated with the decision is the fact that no bonds have been required in these injunctions.
And not every provision in the Federal Rules of Civil Procedure automatically translates over to habeas corpus, and I just don't know if that provision does. If it does, then it has to be addressed. If it doesn't, then you have a different set of rules that you follow.
Would the
Either way,
gentlelady yield for 1 second?
Sure.
Would your
time,
question,
Mr. Chairman,
thank
the
you.
time.
Would your question be for all of these cases, not just the one that you were speaking of?
That is correct, for all of the injunctions that have been issued in these decisions around the country. And I also would ask
Mr. Chairman,
unanimous
time is expired.
I would ask unanimous consent to submit 2 articles for the record. 3 articles. One is the Wall Street Journal article. Another one is the article I was referencing earlier as the U.S. tracks suspected Venezuelan gang members, a look at a group that's helping, and the executive order issued by President Trump.
Without objection, so ordered. We now go to the gentlelady from